The Barbie vs. Bratz rivalry is one of the most intense feuds that the toy industry has ever seen. And that's because when the Bratz dolls hit the scene in 2001, they became the first real competition that Barbie ever had to deal with. At first, the rivalry seemed pretty harmless. The Bratz would throw some not-so-subtle shade at Barbie, and Barbie would undergo some makeovers that made her look suspiciously similar to the Bratz. But after several years, the battle would escalate into a full-out war that resulted in the Bratz being taken off the board completely. Hi, I'm Sasha, and I like to take deep dives into childhood media in order to escape the horrors of adulthood. The Barbie vs. Bratz lawsuit, or more accurately, the Mattel vs. MGA Entertainment lawsuit, ruined my childhood. Picture it. It's 2008. I am 10 years old. I'm doing a Bratz activity book in my room, which has a Bratz comforter set, a Bratz DVD player that I use to watch all of the Bratz movies on repeat, and an organized play corner that I've dedicated specifically to my collection of over 60 Bratz dolls. My mom enters the room to break the news to me that the company that makes Barbie dolls sued the company that makes Bratz dolls, and as a result, there will be no more Bratz dolls in the future. And I handled this news about as well as one would expect. To say I was devastated would be an understatement. Have you ever had two friends that don't really get along, but they're both friends with you? And so you'll hang out with both of them separately, but never at the same time, even though you love them both? That is how I felt about Bratz and Barbie. And this news was like finding out that one of those friends put a hit out on the other one. And it wasn't just the intense sadness that turned this into a negatively formative memory for me. This situation was kind of my first real introduction to capitalism and the corporate world. My perspective that a toy company's primary purpose was to bring joy to kids had been shattered. And so, because I can't afford therapy, today I am attempting to heal that inner child by finding out what exactly went down with this lawsuit. Quick disclaimer that I am not a lawyer, and this video is solely intended for entertainment purposes. I did my best to break this down in a way that I understand, and that hopefully you will too. The Bratz dolls debuted in 2001 and quickly gave the long-standing fashion icon Barbie a run for her money. From 2004 to 2005, sales of Barbie dolls had decreased by 30%, a figure that's directly attributed to the popularity of the Bratz dolls. Naturally, Mattel was not very happy about this, but they would soon become aware of some information that they believed would turn things around in their favor. See, when Bratz were first introduced, it was believed that they were created by MGA Entertainment CEO Isaac Larian. And let's just say that was a narrative MGA was more than happy to have people believe. But Bratz were actually created by a designer named Carter Bryant. And this is what kicks things off, because Bryant was a former employee of Mattel. And there was some questionable overlap with when exactly he worked for the two companies. Bryant was under contract with Mattel from 1999 to 2000 as a hair and clothing designer for the Barbie collectibles department. And while he was under this contract, he pitched the idea for Bratz to what would soon become Mattel's biggest rival, MGA Entertainment, using his own original sketches and a prototype doll that he made from discarded Barbie parts from Mattel. MGA loved the idea and signed Carter Bryant on as an employee. He immediately put in his 2 weeks notice at Mattel and then left permanently to work at MGA Entertainment. However, he did start working with MGA on the creation of Bratz during this 2-week period. So, just based on what I've gone over so far, you may be able to guess where some of the problems arise. First, there's the issue of his overlapping work for the two companies, and then there's the issue of him using Barbie parts to make a prototype doll. Mattel actually didn't seem to be too bothered by the prototype part of the story, and to be fair, Bryant did say they were discarded Barbie parts, but the work overlap definitely created a problem. I don't know why he didn't just tell MGA that he needed to finish his 2 weeks at Mattel before he could start work there, but you know, hindsight's 20/20 and all that. But since MGA had the sense to keep his involvement with the brand under wraps, they definitely should have had the sense to tell him that he needed to wait before he started working with them. While this definitely created a conflict of interest, it actually wasn't the part that Mattel was focused on. The contract that Carter Bryant had signed with Mattel had language, which I'll share here on screen, that was more or less like, if you think it, we own it. Do you remember like 8 years ago when all of those Why I Left BuzzFeed videos were coming out? And a lot of the videos mentioned how their contracts were like, we own you, your likeness, any ideas you have, and your firstborn child. Yeah, it was kind of like that. And this ushers in our first lawsuit. In 2004, Mattel sued Carter Bryant for breach of contract and MGA Entertainment for copyright violation. Mattel claimed that because Bryant was under this contract with them, they were the rightful owner of the initial sketches he created, and therefore the rightful owner of the Bratz name and brand. Carter Bryant has remained adamant that he created the Bratz and the sketches while living with his parents in Missouri during a period of time where he was doing freelance work and was not an employee at Mattel. He had originally worked at Mattel from 1995 to 1998. Then he took a break, during which he claims he came up with the Bratz dolls, and then he returned to Mattel in 1999. Of course, there was no way to prove that he came up with the idea for the dolls during this break, but there was evidence of him pitching the idea to MGA while he was an employee at Mattel. So the primary issue of this court case was really about whether or not the language of his contract gave Mattel the rights to any ideas he came up with while working there, whether it was on his own time or not. I find the idea of a company claiming the rights to any and all ideas an employee has really gross, but that's not what the focus of this legal case is. Bryant would settle out of court with Mattel the day before the trial with MGA began. It's not known how much the settlement was for, but let's be honest, this lawsuit was never really about him. The Mattel vs. MGA Entertainment lawsuit would continue on for 4 more years. But before we get to the details of that case, I'm going to tell you about another lawsuit that came up in the process. On April 13, 2005, MGA Entertainment filed a countersuit against Mattel, accusing it of unfair business tactics of competition by intimidation and serial copycatting of MGA's products. Some sources, including the Bratz Wikipedia page, state that this was the first lawsuit that had been filed between the two companies, but the majority of sources confirm that Mattel was actually the first company to file a copyright infringement lawsuit. I managed to track down one of the court documents for this case, so I can tell you in detail each accusation that was made. The serial copycatting accusation was specifically referring to Mattel's My Scene doll line and its much less successful successor, Flavas. MGA alleged that Mattel had purposely changed the look of its My Scene dolls since their initial debut to look more similar to Bratz dolls. Specifically, that they copied things like Bratz packaging, advertisements, and doll line themes. If found guilty, this would be a violation of trade dress, which in layman's terms is basically like copying someone's signature style. The reason why this is protected by copyright laws is because when it's abused, one company would be able to take advantage of another company's success by mimicking its unique branding to the point of confusing or even purposely misleading consumers into buying their product instead. If you're into skincare or makeup, you may already be familiar with similar cases where brands have done this with the packaging for their supposed dupes that change virtually nothing except the name of the product. Basically, protecting trade dress prevents one company from riding another company's coattails, and it protects consumers from buying a different product than what they intended to purchase. So in this case, MJ was insinuating that My Scene dolls had been changed in a manner that could cause confusion amongst consumers who are looking for dolls with big heads, pouty lips, and big feet, leading to them purchasing My Scene dolls when they were actually looking for a Bratz doll. From my understanding of the appeal I read, it sounded like this accusation was dismissed. Not because it was a completely baseless accusation, but because the case wasn't strong enough to prove the intent. I'll put the language of it on screen, but it basically sounded like an acknowledgement that Mattel did in fact copy Bratz with their My Scene line, but the similarities weren't significant enough to prove that it was done to purposely confuse consumers. Again, I'm not a lawyer, so I can't really say how much of a case they had here, but this accusation kind of pales in comparison to some of the other accusations in this lawsuit. MGA listed several specific instances of Mattel supposedly violating several business laws that are in place to prevent monopolies and unfair competition. MGA alleged that Mattel would threaten their former employees as a way to prevent them from working for the competitor. As part of this accusation, they brought up a lawsuit that Mattel waged against a former executive of theirs that went to MGA. MGA also claimed Mattel would do other, more subtle, underhanded business tactics, such as buying out the entire supply of doll hair from the 2 largest suppliers, forcing MGA to experience a doll hair shortage, which is a problem I have certainly never thought of existing, tampering with MGA merchandise displays by replacing MGA products with Mattel ones, and lying to retailers that MGA was going to discontinue certain products or that MGA was selling its products to other retailers at lower prices, resulting in retailers purchasing less products from MGA. Alongside all of this, there was a more overt accusation that Mattel would threaten to end its relationships with licensing companies, particularly ones in other countries, if they also worked with MJ Entertainment. And they even cited a specific instance of this happening with a UK-based licensing company. It's important to note that Mattel is responsible for way more toy brands than just Barbie, so threatening to terminate a business relationship would have a way bigger impact than just how it relates to Barbie. And I will also note that a lot of the sources I read that talked about sales figures in particular stated that Barbie sales were down in the US while Bratz sales were on the rise, but they still seemed pretty stable abroad. Of course, there's plenty of possible reasons for this, especially given Barbie's global status as a legacy brand, but it does give a little bit of weight to this accusation because it does seem a little odd to me that a competitor would be able to take over a third of the US market, but not have much of an impact anywhere else. The final accusation regarding bad business practices was one that impacted the toy industry as a whole. The Toy of the Year award is an annual accolade given by the Toy Industry Association. MGA won this award in 2001 and 2002. The recipient of this award was originally decided by consumer vote. However, in 2003, the rules were changed so that the winner was decided by fellow toy industry professionals. MGA alleged that this change was supposedly organized by the chairman of the Toy Industry Association, who was also an executive of Fisher-Price, which is a company owned by Mattel. And in 2003, the Toy of the Year award conveniently went to Hokey Pokey Elmo, released by Fisher-Price, while the MGA nominee, Bratz Formal Funk Super Stylin' Runway Disco, came in second. Now, we can't say for sure if this was rigged, but it would be delusional to say that it doesn't look suspicious. Naturally, MGA felt the same way. But when MGA asked for more information on how votes were calculated, they were denied multiple times. Again, very suspicious. Call me crazy, but I don't think the executive of a company that is frequently nominated for this award should have a say in how the winner is determined. Like, at minimum, that is a conflict of interest. Naturally, Mattel applied for an appeal, which is the document I read to get all of this information, but all parts of the appeal were denied, except for the mention of the lawsuit involving Mattel and its former executive. The reason being that MGA's claims about this case implied that the lawsuit was baseless and that it was solely done for retaliatory reasons. I had a hard time finding out how this case concluded, but I believe it ended up being grouped into another case that I'll be going over later in this video. And now for the big boy. This case, which finally received a ruling in 2008, is generally the lawsuit people think of when discussing Mattel versus MGA. So, as a refresher, this was the initial case that was filed by Mattel in 2004, claiming that Mattel is the rightful owner of the Bratz brand. The then CEO of Mattel, Robert A. Eckert, said in a statement that the primary reason they pursued this case was a matter of principle.
Sure, Jan.
However, over the course of this court case, Mattel claimed that Barbie lost over $300 million in profits because of how popular Bratz dolls were, so I think we all know what the real motivation here was. Even though the Bratz dolls were not created on company time or company property, Mattel claimed that because of their employee agreement with Carter Bryant, they were the rightful owner of the Bratz brand, specifically the trademarks for the name Bratz and the character name Jade. These were the only names they would be able to stake any claim over because Jade and Bratz were the only names from the original concept art that hadn't been changed before the dolls went into production. However, they believed that because they owned the rights to the Bratz name, they deserved all of the profits that had been made from it. Mattel demanded $1 billion from MGA in profits for the Bratz, plus interest, and an additional $800 million from Isaac Larian for the part he played in Carter Bryant's supposed breach of contract. In July 2008, the district court ruled in favor of Mattel, holding that Bryant did in fact violate his contract and therefore declaring Mattel as the rightful owner of Bratz. Mattel was awarded $100 million in damages for the supposed copyright infringement, and MGA was ordered to transfer the rights to the entire Bratz franchise over to Mattel as part of something called a constructive trust. This ruling meant that MGA could no longer sell or promote anything with the Bratz name, including dolls, games, movies, spin-off toy lines, or even similar-looking dolls. That included Bratz Kids, Bratz Babies, Bratz Boys, and any additional Bratz characters that had been created since its inception. An interesting detail that I didn't know about before researching this case is that this decision was made by a single judge, not a jury. There was a jury present, but their sole responsibility was deciding which, if any, of the Bratz products the copyright infringement applied to. A Judge Larson was the one who decided that Bryant's contract had been violated, and the one that made the call to transfer all rights to the Bratz products over to Mattel. Now, there's one detail of this case that isn't reported on a lot, but I think it's important when considering biases people carry, whether consciously or unconsciously. Not long before the ruling in this 2008 case, one of the jurors was dismissed for making inappropriate, which is a polite way of saying racist and xenophobic, comments towards Isaac Larian, who is originally from Iran. What's especially sad about this to me is that Larian had expressed concerns about something like this happening to his publicist when the trial had been moved from Los Angeles to a much less diverse Riverside County. To which his publicist replied, "Don't worry, this is America." I know that comment was meant to be well-intentioned in reference to America being the melting pot of the world, but this comment highlighted exactly why Larian was concerned. This is America. The rest of the jury claimed that these offensive comments didn't have an influence on their final decision. And I believe that, because I've read some of the court documents relating to this case, and based on the information that the jury was given, which, spoiler alert, was not all of the information related to the case, I believe the majority of people would have come to the same conclusion that this jury did. And remember, they were only in charge of deciding what the copyright infringement applied to, and their conclusion was that it applied to Jade and Bratz, and everything else was decided by Judge Larson. Because of this problematic juror being dismissed, MJ's lawyers called for a mistrial, but the motion was denied. A few months after the trial, Mattel was granted a permanent injunction, which ordered MGA to immediately stop all production of Bratz dolls and to recall them from store shelves. However, because this court case was still eligible for appeals, this was technically not a final ruling. And as a result, the permanent injunction was overturned a year later in 2009. Now, what's really interesting about the 2008 ruling is that the jury had made it clear that they didn't believe the trademark infringement applied to the entire Bratz brand, only the first generation of Bratz dolls. This decision was based on the initial sketches that were created by Carter Bryant. Outside of the first release, the jury felt that MGA had otherwise expanded the Bratz brand enough to make it into its own unique brand. That's why Mattel was only awarded a small fraction of the money it claimed it was owed. In fact, during the deliberation process, the jury sent the judge a note asking if they could focus the infringement violation on just the first generation of Bratz dolls and not the subsequent releases. Despite this, Judge Larson was apparently confused about what the copyright infringement ruling applied to and took it upon himself to apply the verdict to all Bratz dolls. This is just one of several issues with how this case was handled, which is exactly why MJ would apply for an appeal of this case. In 2009, MGA Entertainment would head to the Ninth Circuit Court of Appeals to have the ruling overturned, and the Court of Appeals found several problems. This appeal is another court document I was able to read in full, so I have plenty of tea to spill for you. The first issue was with how the ruling of Bryant's contract violation was handled. The language of Bryant's contract listed out specific things such as designs, processes, and computer programs as part of what Mattel would be given the rights to, but didn't specify ideas as part of that list. The appeal, written by Judge Alex Kaczynski, stated that the district court failed to recognize the ambiguity of the contract language. And that was made worse by the fact that contracts for other Mattel employees did explicitly list both ideas and inventions, whereas Bryant's contract only listed inventions. During the original case, the court heard testimonies from other Mattel employees which directly contradicted one another. One employee stated that it was common knowledge that many employees did other projects outside of Mattel when they were off the clock. But another employee stated that it was his understanding that everything he created belonged to Mattel as long as he held the title of employee, whether he was on the clock or not. These testimonies obviously highlight the fact that the contract language was far from concrete. Despite this clearly being a crucial piece of evidence, these testimonies were never submitted to the jury. The jury had been instructed to base its decision on the assumption that all work created during Bryant's employment at Mattel belonged to Mattel, and there was no indication that they were told to consider the fact that he created the designs outside of work hours. So the exclusion of this information may have drastically impacted the jury's decision. The court ruled that the only way to fix this issue would be to waive the copyright injunction. On top of that, MJ also argued that since Carter Bryant worked for Mattel specifically as a hair and clothing designer, doll designs didn't fall under the scope of his responsibilities. And therefore, even if the contract did cover ideas, the Bratz concept art would not be included as part of that because he wasn't responsible for coming up with doll designs. The next issue that was identified in the appeal was that the wrong type of copyright protections was applied to this case. There are two types of copyright protections, broad and thin. The difference relies on how many different ways there are to express something. This explanation is quoted directly from the World Intellectual Property Organization. If copyright protection is broad, the challenged work will infringe if it is substantially similar to the copyrighted work. If copyright protection is thin, the challenged work will infringe only if it is virtually identical to the copyrighted work. For example, I am not the only YouTuber who does nostalgic deep dives. Under broad copyright protection, I would be able to copyright claim any video that also covers the Barbie vs. Bratz lawsuit. But under thin copyright protection, I would only be able to copyright claim a video if it uses the same or a nearly identical version of my script, title, and thumbnail. The initial court ruling applied broad copyright protection to the Bratz sketches, and the Court of Appeals argued that it should have applied thin copyright protection, because there is a limited number of ways that body proportions can be exaggerated on a doll. And it also doesn't make sense to apply broad protection to a clothing style that mimics modern fashion. The exact wording was, Mattel cannot claim a monopoly over fashion dolls with a bratty look or attitude, or dolls sporting trendy clothing. Finally, the Court of Appeals ruled that the constructive trust that had been placed on the Bratz dolls was an inappropriate reaction, because Bryant had never actually shared the names Bratz and Jade with Mattel. And even if it had been proven that he violated the terms of his contract, the value of those trademarked names had been created by the efforts of MGA Entertainment. And because of this, Mattel was essentially awarded something worth way more than the actual value of what it was claiming to be the owner of. There's absolutely no reason to assume that Bratz would have become the toy titan that it did if the brand had been managed by Mattel. And based on these prototype dolls that were created by Mattel during the brief period in which they owned the rights to Bratz, I feel pretty confident saying that they most likely wouldn't have come close. So to put it plainly, the court concluded that the case had been sloppily handled and the judge had abused his power with the final ruling. And so, on July 22, 2010, the ruling was overturned. And exactly 3 months later, on October 22, 2010, MGA was granted a new trial due to all of the issues that had been found with the original court case. So we're now back in court over who owns the rights to Bratz. But wait, there's more! Because MJ and Mattel are now also suing each other for stealing trade secrets, also known as corporate espionage. It was difficult for me to find specific details about this particular aspect of the court case, but based on what I could find, it sounds like this was essentially a continuation of that 2005 lawsuit, but with some extra accusations tacked on. The court decided to combine these two cases because, frankly, I think they were sick of dealing with these two companies at this point. And so, a new trial began on January 11th, 2011. In addition to the accusations by MJ about Mattel's unfair business practices, they also alleged that Mattel had sent undercover employees to toy fairs posing as retailers and reporters in order to gain access to the private showrooms of their competitors. And this supposedly led to the creation of multiple Mycene doll lines that had very similar concepts to the Bratz doll lines being released at virtually the same time. Bratz releases Motorcycle Style, Mycene releases Vespacine. Bratz releases Wintertime Wonderland, Mycene releases Chillin' Out. Bratz releases Head Games, Mycene releases Swappin' Styles. A lot of eyebrow-raising coincidences. Unlike the first drawn-out case, which lasted for years, this case only lasted a few months, and the jury came to a decision after only 2 weeks of deliberation. And the verdict was that Mattel was
guilty with a capital Q.
Mattel was found guilty of misappropriation of trade secrets. And on top of that, the jury concluded that Mattel had no right to claim copyright over the Bratz dolls. Mattel was ordered to pay $88.5 million to MGA Entertainment in damages. This amount was later increased to $310 million to cover attorney fees and for making false claims. Basically, since Mattel was the one that started this whole lawsuit and then failed to prove they were in the right, they were being ordered to pay up for wasting everyone's time. But MGA didn't get out of this case completely unscathed. MGA was found guilty of essentially pilfering Carter Bryant as an employee from Mattel. Which, I mean, yeah, I can't really argue with that one. But MGA was only ordered to pay Mattel $10,000 for this, which for a company as big as Mattel is the equivalent of like 5 cents. Mattel unsurprisingly challenged the trade secrets ruling in 2012. After nearly a decade in court, Mattel finally gave up on trying to gain possession over the Bratz dolls, but of course didn't want to pay over $300 million. I found the court document for this appeal as well, and I will admit I had a bit of a hard time fully understanding what determined the ruling for this appeal, but I did my best. I think my brain was starting to short out a bit after reading so many legal documents. To my understanding, the decision regarding the trade secrets allegation was reversed because MGA's claim was deemed not relevant to Mattel's claim and therefore shouldn't have been presented to the jury. Mattel's accusation was that their former employees had shared trade secrets after becoming employees of MGA Entertainment, while MGA's accusations were about Mattel sending employees as undercover spies to toy fairs. So because Mattel's accusation was more specific and named specific parties, the court agreed that MGA's counterclaims were not relevant enough to surpass the statute of limitations, which was 3 years. However, Mattel's motion to dismiss paying the attorney fees was denied. Notably, this appeal went back to the Ninth Circuit and was decided by the exact same judge as the last appeal, Judge Kaczynski, who closed out the document by telling the companies to, quote, play nice. So Mattel started this whole court case, which dragged out for several years, only to end up being the one to pay up at the end of it all. So there you have it, the full story of the Barbie vs. Bratz lawsuit. Now, I know what you might be thinking, if MGA won in the end, then how did this result in Bratz going out of business? Well, there were several reasons. Bratz may have been at the height of its popularity when the lawsuit started, but by the 2008 ruling, the popularity had died down a little bit. And Larian himself admitted that this was because of some strategic errors on MGA's part. At this point in time, the Bratz doll collections had started to rely heavily on gimmicks like being able to style the doll's hair or coming with a nail kit, and largely decentered the emphasis it originally placed on the girls' individual styles. This resulted in the dolls looking really similar to one another. So there wasn't really a need or desire from consumers to buy more than one doll per collection. And on top of that, many of the dolls had a noticeably cheaper look compared to just a few years prior. And there were several collections that only featured Yasmin and Chloe, which went against the diversity that the dolls originally had that appealed to a lot of kids that didn't see themselves represented very much through Barbie dolls. The first step to making a change is acknowledging that there is a problem. But before MGA had the chance to course correct, the permanent injunction was put in place, preventing them from releasing new Bratz dolls for nearly a whole year. This also forced them to delay the release of the movies Bratz Pampered Pets and Bratz Desert Jewels, at least in the US. Although they would go ahead and release the dolls for these movies, which were drastically lower quality than the previous doll collections that had movies associated with them. I was such a diehard Bratz fan that I literally had my mom order DVDs of these movies from Australia. And then I discovered that they were not compatible with my DVD player, so I had to use her computer to watch them. By the time the injunction was lifted in 2009, MGA had some major catching up to do. But unfortunately, they just never really got there. They came back in 2010 with 10th Anniversary dolls, which was basically just a soft reboot. For the most part, they weren't anything special, and the fashions they had were questionable. And while MGA was still trying to get back on its feet, a new competitor had entered the ring and become the second most popular doll line after Barbie, Monster High. MGA would try to compete by both changing the look of the Bratz dolls once again, and most notably by launching a similar witch-themed doll line, Bratzillas. I've already done a video covering Bratzillas, so I'll link that in the description and at the end of this video, but long story short, when these attempts to claw away at Monster High's popularity failed, Bratz dolls were placed on a brief hiatus, only to then come back in the worst way possible. Ew! I do plan to make a video covering the atrocity that is the 2015 Bratz reboot, but for now, I'll just say that Bratz never really got their mojo back. At least, not until their resurgence in the 2020s. By 2010, Bratz just didn't feel cool anymore. And MGA kind of doubled down on that for some reason, even though their edginess is exactly what set them apart from Barbie in the first place. So ironically, even though Mattel ultimately lost the lawsuit, they got what they wanted in the end. Their biggest competitor was out of the game. So my main takeaways from all of this are, it's important to choose your battles, it's important to read any contracts that you sign, and it's especially important to stay true to yourself. But what are your thoughts? Did you know much about the Barbie vs. Bratz lawsuit? What did you think was the most shocking part? And are you Team Bratz, Team Barbie, or Team I don't care, I just like dolls? Let me know. If you liked this video, go ahead and subscribe for more childhood deep dives, and I will hopefully see you in the next one.